हेलो फ्रेंड्स, लीडिंग केस लॉ यूट्यूब चैनल में आप सभी का स्वागत है। आज हम बात करने जा रहे हैं अजीत भारती के जजमेंट की, जिसमें ऑनरेबल इलाहाबाद हाई कोर्ट की फुल बेंच ने ये बताया है कि एंटीसिपेटरी बेल किन परिस्थितियों में बिना सेशन कोर्ट में बिना एंटीसिपेटरी बेल डाले, बिना वहां से रिजेक्शन ऑर्डर प्राप्त किए डायरेक्ट इलाहाबाद हाई कोर्ट में कब एंटीसिपेटरी बेल आ सकती है। इसमें जो हमारी फुल बेंच है, इसने लेजिस्लेटिव इंटेंट को, ऑनरेबल सुप्रीम कोर्ट के जजमेंट को और अन्य हाई कोर्ट्स के जजमेंट को कोट करते हुए और लीगल रीजनिंग के साथ बताया है कि जहां पे कॉन्करेंट जुरिस्डिक्शन है 438 सेक्शन सीआरपीसी का, कि सेशन कोर्ट और हाई कोर्ट में आपकी एंटीसिपेटरी बेल एप्लीकेशन पड़ेगी। तो क्या सबसे पहले आपको हर परिस्थिति में सेशन कोर्ट में ही अपनी एप्लीकेशन लगानी है एंटीसिपेटरी बेल की, या लॉ परमिट करता है कि आप स्पेशल सर्कमस्टांसेस में इलाहाबाद हाई कोर्ट या अपने रेस्पेक्टिव हाई कोर्ट में डायरेक्ट एंटीसिपेटरी बेल एप्लीकेशन मूव कर सकते हैं। फ्रेंड्स, इसमें जो लीगल क्वेश्चन इन्वॉल्व है वह यह है कि अगर स्पेशल सर्कमस्टांसेस में डायरेक्ट इलाहाबाद हाई कोर्ट या अन्य रेस्पेक्टिव हाई कोर्ट में आप अपनी एंटीसिपेटरी बेल एप्लीकेशन मूव कर रहे हैं, तो वो स्पेशल सर्कमस्टांसेस कैसे डिसाइड होंगे। इन सभी बातों को लेकर के बहुत सारे जो एंटीसिपेटरी बेल एप्लीकेशन है, कनेक्टेड मैटर हैं, ये सभी रेफर किए गए कोर्ट के समक्ष, और कोर्ट ने इसमें बताया है कि अगर कहीं ऐसी परिस्थिति आती है कि न्यायपालिका जो हमारी लोअर कोर्ट की है वहां किन्हीं कारणों से एक लंबी स्ट्राइक चल रही है, तो ऐसी परिस्थिति में भी व्यक्ति डायरेक्ट हाई कोर्ट आकर के एंटीसिपेटरी बेल एप्लीकेशन मूव कर सकता है। कुछ परिस्थितियां ऐसी भी होती हैं कि आप किसी अन्य जिला के होते हैं और किसी अन्य जिला में, किसी अन्य डिस्ट्रिक्ट में आपके विरुद्ध कोई मुकदमा पंजीकृत कर लिया जाता है। ऐसी परिस्थिति में भी अगर आप उस जिला में जाएंगे अग्रिम जमानत याचिका लगाने, तो बहुत ज्यादा संभावना है कि वहां की पुलिस आपको गिरफ्तार कर लेगी, क्योंकि आपके विरुद्ध एक मुकदमा पंजीकृत है। ऐसे में आप डायरेक्ट ऑनरेबल हाई कोर्ट आ सकते हैं। और इस लाइट में ये जजमेंट जो है वो बहुत ही महत्वपूर्ण है, क्योंकि एंटीसिपेटरी बेल की जो जुरिस्डिक्शन है वो हाल ही में उत्तर प्रदेश में लागू होती है, और इसको फुल जज बेंच ने जो लेजिस्लेटिव इंटेंट है उसको बहुत ही भली भांति तरीके से लीगल रीजनिंग देते हुए यह माना है कि दोनों, जो हमारी सेशन कोर्ट है और जो हमारी ऑनरेबल हाई कोर्ट है, जब बात एंटीसिपेटरी बेल की होगी तो दोनों का कॉन्करेंट जुरिस्डिक्शन है। लेकिन ऑर्डिनरी और इन जनरल केसेस जो लिटिगेंट है, जो एप्लीकांट है, उसे पहले सेशन कोर्ट जाना चाहिए और फिर हाई कोर्ट आना चाहिए। लेकिन हाई कोर्ट फिर एक बार कहती है कि कहीं से भी यह मनाही नहीं है कि आप डायरेक्ट हाई कोर्ट में एप्लीकेशन नहीं मूव कर सकते। कंडीशन यह है कि वह स्पेशल सर्कमस्टांस होना चाहिए, और वह स्पेशल सर्कमस्टांस कैसा होगा यह फैक्ट टू फैक्ट, सर्कमस्टांस टू सर्कमस्टांस और जुडिशियल डिस्क्रिशन जज डिसाइड करेगा आपके इस मैटर को, कि आपका जो मैटर है वो एक्स्ट्रा ऑर्डिनरी सर्कमस्टांस से रिलेटेड है या नहीं। इस लाइट में अंकित कुमार भाटी का यह जजमेंट ऑनरेबल इलाहाबाद हाई कोर्ट के द्वारा, और आप देख रहे हैं कि कितनी ढेर सारी फाइलें ये कनेक्ट होकर के रेफरेंस के माध्यम से 5 जजेस की खंडपीठ के पास आया है। इसमें हम देख सकते हैं कि ऑनरेबल गोविंद माथुर जी चीफ जस्टिस हैं, फिर रमेश सिन्हा जस्टिस हैं, मिसेस सुनीता अग्रवाल जस्टिस, यशवंत वर्मा जी जस्टिस और राहुल चतुर्वेदी जस्टिस हैं। और इसमें जो काउंसिल हैं वो श्री गौरव कक्कर, इन्होंने आर्गुमेंट किया है, और इनके साथ अन्य भी बहुत सारे लोग, और काफी विस्तृत जजमेंट है। तो इसे हम देखेंगे कि, और इस पार्ट में हम केवल उस फाउंडेशन को देखेंगे कि जिस क्वेश्चन ऑफ लॉ को लेकर के ये मैटर रेफर किया गया है। अब हम देखते हैं इस जजमेंट को। पहला जो जजमेंट ग्राउंड है जिस पर यह रेफर किया गया सिंगल जज के द्वारा, वह है वेदर द कोर्ट वुड हैव नो जुरिस्डिक्शन टू रिजेक्ट द एंटीसिपेटरी बेल आफ्टर कंसीडरिंग द ग्राउंड्स ऑफ कंपेलिंग रीजन मेंशन्ड इन द एफिडेविट बीइंग फाउंड नॉट अपीलिंग, व्हिच वुड अमाउंट नथिंग बट टू अप्रोच दिस कोर्ट डायरेक्टली। Secondly, whether amongst the grounds which have been enumerated in the judgment in the case of Vinod Kumar, the grounds at serial A requires any reconsideration so as to preclude the co-accused approaching this court, mean high court directly, in case the other co-accused regular bail anticipatory bail is rejected by the court of session, and whether he be also subjected to filing such an affidavit showing therein the circumstances in which he had to feel compelled to approach this court directly. Third question of law is whether amongst the grounds which have been enumerated in the judgment in the case of Vinod Kumar Supra, the ground at serial B requires any reconsideration as to whether an accused who is not residing within the jurisdiction of session court concerned faces a threat of arrest should be allowed to approach the High Court directly to move an anticipatory bail application by logic given in para 6 of this judgment? And the last question is whether such anticipatory bail application which do not contain any compelling reason to approach this court directly should be entertained. While passing the referral order, the learned judge also suggested the formation of bench larger than the one who had rendered the judgment in Onkar Nath Agrawal and others versus state, a decision rendered by 3 learned judges of this court. The reference came to be made in backdrop of the decision rendered in Vinod Kumar versus state of UP and another, in which the learned judge framed the following question for consideration. And now these questions should be answered. The nature of the concurrent jurisdiction conferred by section 438 CRPC. Whether parties should be commanded to necessarily approach the session court first before invoking the jurisdiction of this court under section 438 CRPC. In what circumstances can the High Court be approached directly under section 438 CRPC? Exceptional or special circumstances. The perceived conflict between the decision rendered in Harendra Singh alias Harendra Bahadur versus state and Neeraj Yadav and another versus state of UP. Impact of the explanation to section 438 to CRPC. The period for which anticipatory bail should operate. Upon due consideration of the decision rendered on the subject by the court as well as those rendered by different high courts of the country, the following conclusion came to be recorded. A. Section 438 CRPC on its plain terms does not mandate or require a party to first approach the session court before applying to the High Court for grant of anticipatory bail. The provision as it stands does not require an individual first being relegated to the court of session before being granted the right of audience before this court. Notwithstanding concurrent jurisdiction being conferred on the High Court and the Court of Session for grant of anticipatory bail under section 438 CRPC, strong, cogent, compelling and special circumstances must necessarily be found to exist in justification of the High Court being approached first without the avenue as available before the Court of Session being exhausted. Whether those factors are established or found to exist in the facts of a particular case must necessarily be left for the court to consider in each individual matter. The words exceptional or extraordinary are understood to mean a typical, rare, out of the ordinary, unusual or uncommon. If the jurisdiction of the court as conferred by section 438 CRPC be circumscribed or be recognized to move only in exceptional situation, it would again amount to fettering and constricting the discretion otherwise conferred by section 438 CRPC. Such construction would be clear in conflict of the statutory mandate. The ratio of Harendra Singh must be reconsidered to be the requirement of establishing the existence of special, weighty and compelling reasons and circumstances justifying the invocation of the jurisdiction of this court, even though a wholesome avenue of redress was available before the Court of Session. What would constitute special circumstances in light of the nature of the power conferred must be left to be gathered by the judge on a due evaluation of facts and circumstances of a particular case. It would be imprudent to exhaustively chronicle what would be special circumstances. It is impossible to either identify or compendiously postulate what would constitute special circumstances. And the Honorable Supreme Court judgment in CBI spoke of the imperfect awareness of the needs of new situation. It is the constraint which necessitates the court leaving it to the wisdom of judge and discretion vested in him by statute. While the explanation may be created an avenue for an aggrieved person to challenge an order passed under section 438(1), it can't be construed or viewed as barring the jurisdiction of the High Court from entering an application for grant of anticipatory bail, notwithstanding that prayer having been refused by the Court of Session. Till such time as the question with respect to the period for which an order under section 438 CRPC should operate is answered by the larger bench, the court granting anticipatory bail would have to specify that it would continue only till the court of summon the accused based on the report that may be submitted under section 173(2) CRPC, whereafter it would be open for the applicant on appearance to seek regular bail in accordance with the provision made in section 439 CRPC. In Ankit Bharti and state of UP and another, the learned judge, while referring the matter to this full bench, expressed certain reservation with respect to the answers rendered in Vinod Kumar while dealing with the question of what would constitute special circumstances. Enabling an applicant to approach the High Court directly by way of a petition under section 438 of the Criminal Procedure Code, the doubt itself was expressed in respect of contingencies A and B as set forth in Vinod Kumar while answering question D. In Vinod Kumar, the learned judge, while dealing with question D, held thus: Harendra Singh leaves a window open with the learned judge observing that requiring the party to invoke the jurisdiction conferred on the Court of Sessions must be recognized as normal course and the High Court entitled to be moved only in extraordinary circumstances and special reasons. The learned judge further went on to observe in the ultimate conclusion drawn that for extraneous or special reasons, the High Court could also exercise power conferred under Section 438 CRPC, notwithstanding the Court of Sessions having not been moved. What appears upon a holistic reading of that decision is the intent of the learned judge to convey the duty of the applicant approaching the High Court to establish the existence of exceptional and special circumstances. The only clarification which therefore would merit being entered is with regard to the requirement of proving the existence of extraordinary or exceptional circumstances. The words exceptional or extraordinary are understood to mean atypical, rare, out of the ordinary, unusual, or uncommon. If the jurisdiction of the court as conferred by Section 438 CRPC be circumscribed or be recognized to be moved only in exceptional situation, it would again amount to fettering and constricting the discretion otherwise conferred by Section 438 CRPC. Such a construction would perhaps run the risk of being again viewed as being in conflict of the statutory mandate and the discretion conferred. In the considered view of the court, what the learned judge did seek to convey and hold in Harendra Singh was the requirement of establishing the existence of special, weighty, complaining regions and circumstances justifying the invocation of the jurisdiction of this court, even though a wholesome avenue of redress was available before the Court of Sessions. Regard must be had to the fact that the Constitution bench in CBR had an occasion to deal with the correctness of the restrictions as formulated by the full bench of the Punjab and Haryana High Court on the exercise of power under Section 438 CRPC. Dealing with that aspect, the Constitution bench clearly held that the exercise of discretion as statutorily conferred can't be confined in a straitjacket. This simply, since it would be impossible to either prophesize or foresee the myriad situation in which the jurisdiction of the court may be invoked. It was for the aforesaid reasons that the Constitution bench held that this aspect must be left to the judgment and wisdom of the court to evaluate and consider whether special circumstances exist or are evidenced by the facts of a particular case. The court deems it apposite to extract the following paragraph from the decision rendered by the Constitution bench. This is not to say that anticipatory bail, if granted, must be granted without the imposition of any condition. That will be plainly contrary to the very terms of Section 438. Though subsection 1 of that section says that the court may, if thinks fit, issue the necessary direction for bail, subsection 2 confers on the court the power to include such condition in the direction as it may thinks fit in the light of the facts of the particular case, including conditions mentioned in clause 1 to 4th of that subsection. The controversy therefore is not whether the court has the power to impose condition while granting anticipatory bail. It clearly express has that power. The true question is whether by process of construction the amplitude of judicial discretion which is given to the High Court and the Court of Session to impose such condition as they may think fit while granting anticipatory bail should be cut down by reading into the statute condition which are not to be found therein, like those evolved by the High Court or canvassed by the learned Additional Solicitor General. Our answer clearly and apathetically is in the negative. The High Court and the Court of Session to whom the application for anticipatory bail is made ought to be left free in the exercise of their judicial discretion to grant bail if they consider it fit so to do on the particular facts and circumstances of the case and on such condition as the case may be warrant. Similarly, they must be left free to refuse bail if the circumstances of the case so warrant on consideration similar to those mentioned in Section 437 or which are generally considered to be relevant under Section 439 of the Code. The generalizations on the matter which rest on discretion and the attempt to discover formulae of universal application when facts are bound to differ from case to case frustrate the very purpose of conferring discretion. No two cases are alike on facts and therefore court had to be allowed a little free play in the joints if the conferment of discretionary power is to be meaningful. There is no risk involved in entrusting a wide discretion to the court of session and the High Court in granting anticipatory bail, because firstly, these are higher court manned by experienced persons. Secondly, their orders are not final but are open to appellate or revisional scrutiny, and above all, because discretion have always to be exercised by court judicially and not according to whim, caprice or fancy. On the other hand, there is a risk in foreclosing categories of cases in which anticipatory bail may be allowed, because life throws up unforeseen possibilities and offers new challenges. Judicial discretion has to be free enough to be able to take these possibilities in stride and to meet these challenges, while dealing with the necessity for preserving judicial discretion unhampered by rules of general application. Said in Hyman versus Rose, I desire in the first instance to point out that the discretion given by the section is very wide. Now it seems to me that when the act is so express to provide a wide discretion, it is not advisable to lay down any rigid rules for guiding that discretion. I don't doubt that the rules enunciated by the master of roles in the present case are useful maxim in general, and that in general they reflect the point of view from which judges would regard an application for relief. But I think it ought to be distinctly understood that there may be cases in which any or all of them may be disregarded. If it were otherwise, the free discretion given by the institute would be fettered by limitations which have nowhere been enacted. It is one thing to decide what is the true meaning of the language contained in an act of parliament. It is a quite different thing to place condition upon a free discretion entrusted by institute to the court, where the conditions are not based upon statutory enactment at all. It is not safe, I think, to say that the court must and will always insist upon certain things when the act does not require them, and the facts of some unforeseen case may make the court which it had kept free hand. Judges have to decide cases as they come before them, mindful of the need to keep passion and prejudice out of their decision. Dear friends, if you people require that we will discuss this judgment again in Hindi and also make a video on this judgment, that judgment tell us about in which circumstances you or applicant can approach this honorable court or any high court having power and capacity as a high court. So dear friend, thank you.